Welcome once again to another program of Issues in the News, where we discuss the important events that would have taken place in Guyana over the past week or so. And as is the norm, we always have a packed agenda of issues to discuss. I want to welcome all of you who are joining us on television in Guyana, and I also want to welcome all of you who are joining us on Facebook Live across the length and breadth of Guyana, the Caribbean, North America, Europe, Asia, the Middle East, and as far as Australia. Welcome to another program of Issues in the News. Share this program. Press that share button on your phone, on your iPad, on your tablet, on your phone, your computer, whatever platform, whatever device you're using to look at this program. Share the program so that all your viewers, all your followers, all your friends can join us in tonight's discussion. We want the widest possible audience and viewership, so share the program wide and far. Use the comment section on the phone to express your views, ask questions, pose issues, seek clarifications. We want the program to be as interactive as possible. Jamil Azmir, Indira Sadhu, Fazlur Ali, Bibi Hussein, Dindyal Devkisoon, Kumar Singh, Gayatri Singh, Annette Sumra, Rajendra Etwaru. Welcome all of you, and share the live, share the program so that all your friends and all your followers can join us in tonight's discussion. So let's begin. I see in the news circulating is a statement, or rather a letter, addressed to the chairperson of the Guyana Elections Commission, sent by leader of the Alliance for Change, Mr. Nigel Hughes, in which Mr. Hughes complains that the Attorney General is the legal advisor of GCOM, and he raises deep concerns about that alleged development. Permit me to clarify for the public that the Attorney General is not the legal advisor of GCOM. Neither has the Attorney General ever held himself out to be the legal advisor of GCOM. The Attorney General is the most senior legal officer of the state of Guyana and is the legal representative of the state of Guyana. He is also the principal legal advisor of the government of Guyana. And in those many capacities, agencies of state has always historically sought the legal opinion of the Attorney General. This is different from the Attorney General being the legal advisor to those state agencies. The difference, subtle as it is, one would expect would be appreciated by a lawyer such as Mr. Hughes, but obviously the nuance is lost upon Mr. Hughes. So he accuses the Attorney General of being the legal advisor of GCOM. Historically, the legal opinion of the Attorney General has been sought by GCOM for many decades. And the Attorney General's office has never declined a request to offer a legal opinion to important state agencies, including, of course, GCOM. I challenge the three commissioners who are there now to deny that during 2015 to 2020 that they did not approach the Attorney General chambers for legal guidance on many issues. I know that they did. The staff at the Attorney General chambers who were there during that period confirmed to me that GCOM and the three government commissioners at the time, Messrs. Alexander, Corbin, and Trotman, sought legal guidance from them. So did the commission. I distinctly recall during the 2020 elections impasse, long after March the 2nd, I personally saw the government commissioners at the time going into the Attorney General chambers compound to seek legal guidance in relation to Order 60. Let them deny that. That was the order for the recount of the ballots that was agreed upon by President Granger and Leader of the Opposition, Bharat Jagdeo. I saw when they went into the compound of the Attorney General chambers with that document in their hand to seek legal guidance. We never accused the Attorney General then of becoming or of being the legal advisor of or to GCOM. The GCOM chair, acting on behalf of the Commission, wrote to the Attorney General, sought certain clarifications and his opinion on some of the recent amendments to the National Registration Act and the Representation of the People Act. And the Office of the Attorney General offered the opinion and the legal guidance. That is all that happened. So, Mr. Hughes, for your benefit, the Attorney General is not the legal advisor of GCOM, but offered his opinion as was requested, and has offered his legal opinion to many independent constitutional agencies and statutory agencies who have from time to time have sought legal guidance and legal opinions. That doesn't make the Attorney General the legal advisor of those agencies. So I thought that I would put that to rest. And as I am on the Alliance for Change, my attention was drawn to another statement issued by Mr. Hughes and posted on his Facebook page Well, let me say the statement was issued by the Alliance for Change, but carried on Mr. Hughes's Facebook page as a post. And it sought to categorically reject a mischaracterization and inaccuracy regarding the role of the AFC in ongoing coalition discussions. That's the first paragraph. The second paragraph reads, first and foremost, at no point has the AFC demanded the presidency, nor have we insisted that our nominee must lead in any coalition. Such claims are wholly false. That is what, in the main, the contention is of the AFC in a statement issued today. Let me read it again. First and foremost, at no point has the AFC demanded the presidency, nor have we insisted that our nominee must lead any coalition. Such claims are wholly false. And I recall that I read somewhere not so long ago that the AFC made that precise demand in coalition talks, or when they were about to go to coalition talks. I read that in the newspapers. And I did my research, and I was not wrong. In Stabroek News, edition of the 31st of March 2025, there is a bold caption, and the caption reads, AFC wants Hughes as presidential candidate in coalition with APNU. I don't know if you can read it from that distance. My operator is telling me that you cannot. But all of you who have computers can go into the Stabroek News archive of March 31st, 2025, just a few months ago, and you will be met with a bold headline that reads, AFC wants Hughes as presidential candidate in coalition with APNU. And let me read just the first paragraph of that article. And it says this: the Alliance for Change last evening announced that its leader, Nigel Hughes, will be the presidential candidate should it join forces with APNU for the 2025 elections, and the party would have to be given 40% of positions at all levels of government, with 60% going to APNU. Let me read that opening paragraph for you. The Alliance for Change last evening announced that its leader, Nigel Hughes, will be presidential candidate should it join forces with APNU for the 2025 elections, and the party would have to be given 40% of the positions at all levels of government, with 60% going to APNU. My friends, that is what is reported in the Stabroek News, and you heard, I read earlier, verbatim from an Alliance for Change press statement issued today. And there is a serious collision course in those two statements that I have just read. The Alliance for Change is now denying that they ever demanded the presidential candidate position in any coalition talks with APNU. But I have just read to you a Stablet News article that is headlined. Oh, you're putting the link to the comment? The link to the article is in the comments section, I'm told by my operator. And look at it. Look at the article. AFC wants Hughes as presidential candidate in coalition with APNU. And this is the level, or rather the lack of credibility, that is being publicly exhibited for the public's consumption, for the electorate's consumption. A blatant inconsistency, an unvarnished falsehood. That is what is being peddled here. And these are things that are so easily verifiable, yet the inaccuracies are being peddled. I don't know how they would have conceived that this would not have been uncovered. From the time I saw that statement today, I knew that I read a contradictory position elsewhere. And it didn't take me a couple minutes to find it. How can you take these people seriously? And that's, first of all, that's all that they're concerned about. Negotiating as to who will get what, when, and who will be the presidential candidate. Now, when things are not going in their way, you find now deniability, and they are now denying the very statements that they have made. Nigel Hughes, for example, again, if I may revert to the previous issue that I dealt with, one of the main themes running through the letter of complaint that he wrote to the chairperson of GCOM is to accuse the Attorney General of a conflict of interest, because I can't be advising the government, I suppose, and be advising an independent tribunal. And of course, I am a politician. And he said the Attorney General visible political activism on behalf of the ruling party, including frequent appearances on issues in the news, where he routinely disparages political opponent, further compounds the problem. I'm not disparaging you, Mr. Hughes. I'm telling the audience that it appears as though you and your party have lied. That's a statement of fact. It may have a disparaging impact, but I don't intend to disparage you. My intention is to put the truth out there. And I put what you said today, and I put what you said on the 31st of March 2025. And they are in violent conflict with each other. That is not disparagement. That is full and frank disclosure of two statements that do not coincide. And then he accuses me of conflict of interest. This gentleman is the epitome of conflict of interest in Guyanese politics, in a manner never seen before. This gentleman, and it's not conflict of interest that is of any recent vintage, it's conflicts of interest that dates back to a long time ago, when he was the lawyer for Site Global, and his wife firm was the PR for Site Global, the company behind the Amila Hydro Fall project. And in conflict with that position, his wife was in the parliament and his party was in the parliament, publicly denigrating that project and eventually voting it down. So on the one hand, he's advocating for the project and working for the people, and then on the other hand, he's backstabbing them in the National Assembly and in the public domain. That is a conflict of interest, Mr. Hughes. And then the position that he takes on law and order, crime and criminality. This person tells us that he wants a lawful society. He advocates for the upholding of law and order. And then he is the leading lawyer representing persons charged with committing the most violent crimes in the country. Now, I am not saying that he doesn't have a right to do so. Every attorney at law has a right to represent clients. But the attorneys at law who represent these clients who are charged with these violent offenses can't at the same time be advocating for a non-violent society. They can't, because it would be a conflict for them to speak from both sides of the mouth. Mr. Hughes represented the persons charged with the Lusignan massacre, with the Bartica massacre. That's a level of cases. That's a type of cases. And then, not normal cases, not mere homicide, but massacres. And yet wants to speak about a lawful, non-violent, crime-free society. It doesn't go hand in hand. And then we come, and he takes it a step further. As is reported in the press, he's representing criminals who have been convicted now, so I can call them criminals, and who have since died. And he is still trying to clear their names, and that is what he said to the Court of Appeal, as is reported in the press. He's trying to protect their reputation. These are people who have been charged and convicted of multiple murders. Multiple murders. And they are dead. I think they were shot by the police while they were trying to commit more murders or more crimes. And Mr. Hughes, after they are dead, still representing their interest in order to protect their reputation. Now, in criminal cases, when the accused person dies, the outstanding legal principle is that the appeal is abated by death. It's not like a civil case where the estate of the deceased person carries on or can carry on the action. In a criminal case, because a personal thing, when the defendant or the accused or the appellant dies, the criminal case dies. You can't jail a representative. You can't jail the administrator of the estate or the executor of the will for a crime committed by the deceased person while he was alive. So logically, the right of appeal dies when the person dies. And that's the position throughout the British Commonwealth, and I believe all over the world. notwithstanding that established legal principle, Mr. Hughes is arguing a case on appeal for appellants who are dead and continues to argue it despite objections from the prosecutor. So here you have this person who wants law and order in a society going an extra 100 miles to represent a person convicted of multiple violent murders, and does so after they are dead, and still purport to represent them in the court. That must be a world record. But that is the position. And then you have the mother of all conflicts of interest, and that is Exxon. He tells you to your face that he will represent Exxon and not represent the interest of Guyana and Guyanese, and that he will continue to do so until he's elected president. He doesn't leave you to infer. He doesn't remain silent on the matter. He chooses to tell you that he will stand with that company until, against your interest and against the interest of the state, and he will stand with that company until you elect him the president. Digest that for a minute. Recently, I read in the news some disingenuous attempt to say that he is no longer acting for Exxon, that his firm is. My friends, once your firm is, you are. When the reporter was asking the person who was speaking on behalf of the firm whether Mr. Hughes is benefiting financially from the proceeds of the firm, the person who was answering for the firm said, that is not your business. So it is not your business, the people of Guyana's business, whether he's benefiting from that firm. But you must know that he is. That's why it is a firm. And I don't think he will seriously deny that. But there was this feeble attempt to create some mirage that may distract the uninitiated. And if that is not bad enough, just last week, I heard one of his leaders say, David Patterson, that the AFC will renegotiate the 2016 lopsided agreement. You know, if these things were not happening real and somebody were telling you these things, you would think that they are fanciful stories. You would think that they are fables. These things are real. So the AFC, through its leader then, Raphael Trotman, is the one who signed the contract in the first place. They can't explain sensibly why they entered into the contract in the first place. Up to now, you can't get a sensible explanation. I heard one explanation is that cabinet instructed. But then you have other members of cabinet who said that they never saw the contract. But cabinet can't this Trotman is a lawyer. Where is the Attorney General in all of this? Was he briefed? Not that he would have made any sensible intervention from all that we know. Nothing sensible would have come from that direction anyhow. But this is the man who indicted us in the first place with a contract that I've described 10 years ago as the most lopsided contract in the world. And we are 3 months before an election, and the very party that indicted us with this burden is now telling us, vote for them, we are going to renegotiate. They put us there in the first place. And up to now they can't tell us why they put us there. But they want you now to believe that they will renegotiate. And while they're saying that, the man who is saying that, David Patterson, is sitting next to the lawyer of Exxon, whom presumably he will have to negotiate with, and that is Mr. Hughes, at the same press conference. So Patterson is telling you that he will have to renegotiate with Mr. Hughes, because Mr. Hughes remains Exxon lawyers, or one of them. Do you understand that I'm not making these things up, and these things are actually happening? And I can continue to give you many, many examples. Mr. Hughes is writing here to the GCOM chair, complaining that if the Attorney General gives advice to GCOM, somehow that will undermine the democratic process. That is what Hughes is complaining about to GCOM and to you, because he made this letter public. But his party, for 5 months, actively participated in undermining the will of the people. At least they tried to. They tried to rig the elections. They tried to subvert the will of the people. They tried to derail the democratic process. Mr. Hughes' party did that. The party that he's leading. They claim that they won the elections, and up to now they can't produce their statements of poll. 100 governments condemned their actions as a blatant and flagrant attempt at electoral fraud. And when Hughes is being asked about his party's role, he says that he doesn't know. He has to find out what role they played. He has to find out what role they played. And this gentleman writing GCOM to say that the Attorney General offering a solicited opinion on legislation that the Attorney General Chambers drafted will undermine democracy. I am not saying at all that GCOM should accept my opinion, but they asked for it. And as a responsible Attorney General, I offered, as I do to many state agencies. They don't have to act upon it. But this gentleman should not be writing these things. He should not be scribing them. Neither should he should be oralizing them anywhere, at least not in the public. So I thought that I would deal with those matters as an introduction. But as I am on elections, I might as well continue. So another presidential aspirant who thinks, well, let me begin this way. I have reliable information that has persuaded me to the conclusion that a newly minted presidential aspirant who may be unsure that he will be able to attract persons to be on a list for him to contest the elections in accordance with the Constitution, has appointed two surrogates, Christopher Ram and Vishnu Bandhu, to file two cases in the court in which they are asking the court to invalidate the electoral process and to invalidate sections of the Representation of the People Act because, according to them, it does not allow an individual to contest the elections. Apparently, this presidential aspirant fears that if he doesn't get a list to submit to GCOM as is the requirement, then he may not be able to contest the election because the system doesn't allow him. That's his understanding of it. Well, my friends, all over the world, in constitutional democracy like ours, elections are held at periodic intervals, and the system by which the elections are held, or the electoral systems, are invariably established and set out in the Constitution of the democracy. And almost all the major democracies of the world, in particular the Commonwealth countries' constitutional systems, are constructed that way. And you have different various electoral systems. You have first past the post, and you have proportional representation. Those are the two main ones, at least in the English Commonwealth. And the countries choose one of. You want to get a copy of the Constitution for me? So, the Constitution, being the supreme law and the main source of law, provides for all important matters such as that. It sets up the system of governance. It sets up the system of adjudication at the level of the judiciary. It sets up the parliament. It sets up the local government structure. It establishes all the rights and freedoms of the individuals. It tells you what are the important checks and balances. And of course, it tells you how elected representatives that will occupy many of these offices, including government and the legislature, are elected. It is the Constitution that says that. Our Constitution is no different. Our Constitution is no different. So, our Constitution has established a system. Now, I want to read quickly from a couple of sections in the Constitution. So, there's a section, Article 9 of the Constitution says, sovereignty belongs to the people. Sovereignty belongs to the people who exercise it through their representatives and the democratic organs established by or under this constitution. So the sovereignty of Guyana belongs to the people, and the people exercise it through their elected representatives, and through democratic organs established by the constitution. Well, one of those democratic organs is the electoral process. One of the democratic organs is through the parliament. And the people of Guyana, in the exercise of this sovereign power, they have told their elected representatives, this is the system that we want. And that system currently is called a proportional representation system. Article 60 says this: election of members of the National Assembly shall be by secret ballot and subject to the provisions of Article 162. Such number of members of the National Assembly as determined by the Assembly shall be elected in accordance with the system of proportional representation as prescribed by Article 161. So the system is PR, proportional representation, and it is set out more fully, as this section tells you, in Article 161 and 2. But before I get to that, let me remind you that at one point in time, the people of Guyana had instructed their representatives that they wanted another system, and that was the first past the post system. And we had that from 1953, when we had our first elections, all the way to 1964. And then the people changed from that, and they moved to proportional representation. And during the first past the post system, and when we had that system, that's a different system. That's where you have a constituency identified, which is a geographic area, and you have a candidate, a singular person who is contesting that. And he can contest on a list if he wishes, or he can contest by himself. That system, the people said that they want to change, and in 1964 they changed it, and they introduced the proportional representation system, and we have had that since, and we have gone through many modifications of it. The last modification came in the 1999-2001 electoral constitutional reform process, where the people were widely consulted, and they made alterations to the PR system. But they kept the PR system, but they made many alterations. And those of us who are aware of the historical evolution of our constitution and the electoral system would know of the manifold changes that were made. But they kept in the main the basic structure of the PR system. So it's not that the people didn't change the system, the PR, they altered it, but they altered it exactly how they wanted to alter it. And that is what is set out in 160 of the Constitution. That you can go to the elections, individuals can contest, but you must be part of a list. And the list is what the voters will vote for. And the head of that list that receives the most votes shall be deemed the president. The presidential candidate of the list that receives the most votes at that election shall be deemed to be the president. That is the system we have. Every country has its own system. That is established in the Constitution, and the ROPA and the National Registration Act add flesh to that skeleton, and they establish the electoral machinery based upon the constitutional prescription. Nothing is wrong with that. Every country has devolved that way. Trinidad, for example, that went to elections 2 months ago, they have the first past the post system. can an elector in Trinidad a politician in Trinidad file an action in the court and said, look, you have a false party post system here, but I would like to participate in an election with a PR system. But you are denying me that right. So I want you to, I don't know, declare the first past the post system unlawful. No sensible. The matter is before the court. But I think that I have put out there enough for you to understand that these actions are fishing expeditions. They are fishing expeditions. We have had this system since 1964. Reckon how many decades. And then we went through some changes in 1999 and 2000. We went through some changes in 1980 as well, when we got a different constitution. You know how many decades have passed? From 2000 to now, we passed almost 4 elections without any challenge. Now, someone is awoken from some slumber who has a lot of money to play around with, so appointed surrogate litigants to file proceedings in the court to challenge the electoral system a few months before the elections. I saw in the newspapers today that Carter Center will be here to observe the 2025 elections, and I welcome that. Obviously, many more international observer teams will be invited and will be welcomed to observe the elections. The People's Progressive Party fought 28 years to get observers to come here, because for 28 years the PNC rigged the elections and they did not want observers to be present, and they blocked observers out. It's only in 1992, after 28 years of being in the trenches and struggles, that one of the things that we won was the right to invite international observers to come and observe the elections. And every year since then, we have had that. And every one of those international observers have certified all the elections held from 1992 to 2020 as free, fair, and democratic. All of them. In 2020, they blocked, was during the COVID, and by their shenanigans, they delayed the declaration of the results as they attempted to pervert the results through bingo and through other instrumentalities. When the Carter Center and the other observers team left, they blocked them from attending the recount, which took place some 2 months after the elections. Carter Center was denied entry. We are back in government, and as far as possible, we will invite as many of the reputable international observer missions, because we have nothing to hide. We want transparency. And we know who the electoral miscreants are. And we know what their capabilities, tendencies, and proclivities are. So the more the observer teams, the safer the electoral process. This Thursday, we will be opening a children's court at Charity on the Essequibo coast. That's this Thursday. A children's court will be opened by the Chancellor, Chief Justice. Yours truly will be there at Charity on the Essequibo coast. It will be the first children's court in the county of Essequibo. We have two in Demerara. I don't think we have one in Berbice as yet, but we are now getting one in Essequibo. And these are specialized courts that will hear and determine cases in relation to children. You know, there is a special legal and statutory dispensation to treat with cases involving children. It is the Juvenile Justice Act, and that Juvenile Justice Act, in accordance with internationally established protocols and principles and policies and procedures in relation to juvenile justice, outlines how children are to be tried. And the courts are designed differently to allow for those practice, procedures, principles, and precepts to be observed and promulgated and activated. So that's why the physical structure of the building is different from an ordinary court that you may be accustomed to. Last year we opened one at Wales on the west bank of Demerara in Region 3. So we will be moving to Essequibo Thursday to launch that one. As I am on the justice sector, I am pleased to report that the Restorative Justice Program that we launched is up and running and is having an impact. We have restorative justice centers on the east coast of Demerara, and they are serving courts operating on the magistrates' courts, operating on the east coast of Demerara as well as in Georgetown. We have an office in Georgetown. We have one at Triumph in the RDC compound of Region 4. And those two centers are serving Region 4. We have one operating out of the probation office in Region 5. We have one operating out of the probation office at Port Droin, West Bank, Demerara. And that one in the West Bank of Demerara provides services to Venenhoop, Magistrates Court, Wales, Leonora, Wakenham, and Legwan. And the one at Region 5 provides, that's in the probation office building of the Ministry of Human Services and Social Security, located at Fort Wellington, Berbice, and that is providing services to the Magistrates Court at Fort Wellington, Mycone, and Blairmont. So it's a slow process, but we are spreading it out gradually, and soon we will be countrywide. The information I have is that 9 cases have already been referred to the center at Region 4, 9 cases, 2 of which have already been resolved, and 7 are under active consideration. So the Restorative Justice Project involves the participation of community leaders in the justice system in relation to minor offenses under the supervision of a magistrate. And we are seeing the progress being made. So we'll continue to work to ensure that we deliver, we make the restorative justice program countrywide, and we induct it into the more and more into the criminal justice system across the length and breadth of Guyana. We are we are concluding the cash grant distribution, the Because We Care cash grant. And as you know, we have increased it from 40,000 to 50,000 per child. And we have already distributed over 205,000 of our students across the country have benefited from this initiative. 205,000 students have already benefited from this initiative and would have received a total of $11.28 billion. $11.28 billion have gone into the pockets of parents and guardians of 205,000 children. This is what APNU and AFC deprived our children of for 5 consecutive years. $11.28 billion just this year alone. It's now 50,000. It was 10,000 under them, and they abolished it. Today, they want to tell you how much they care about our children. These people are a pack of jokers. A pack of jokers. And I don't want to, my time is up now. I can't continue. We have 2,000 persons who graduated from the Guyana Online Academy, the GOAL program. We just concluded the graduation exercise. 2,000 Guyanese, government paid every cent. Universities across the globe, 2,000 scholarship program graduates. That is the type of transformation that we are speaking about. My friends, thank you very much for spending the past hour with me. I believe that we have covered some important topics, and we have covered many topics, and we have gone into details in some important ones. I want to thank you very much for spending the past hour with me. Next week, Tuesday, we will continue our discussions, and I want to wish you the best of the rest of the evening, and stay healthy and stay safe until we meet again next week, Tuesday, for another edition of Issues in the News. May God bless you. Take care. Thank you.